This is Constitutional Rights in Black and White. This is a case about cell phones. Cell phones work by connecting to cell sites, sometimes called cell towers. There are thousands of these sites all over the country, nearly 500,000 of them, maintained by various cell phone carriers. Every minute of the day, your cell phone connects to these sites multiple times, looking for a signal. Every time your phone connects to a cell site, it produces a record, a time-stamped record of the physical location of your phone. These records are called Cell Site Location Information, or CSLI. They tell your cell phone carrier where your phone is, over and over, every minute, every day. In 2011, prosecutors suspected that Timothy Carpenter might have been involved in a series of robberies in Detroit. So they got his cell phone number. Then they went to two cell phone carriers, Metro PCS and Sprint, and asked them for 4 months' worth of CSLI tracking data for Mr. Carpenter's phone. They got nearly 13,000 CSLI records, about 100 data points per day, each one revealing the approximate location of Mr. Carpenter's phone. The government prosecuted Mr. Carpenter for those robberies. At the trial, they used those thousands of CSLI records to show where Mr. Carpenter had been for 4 months, specifically around the time of each of the robberies. In closing argument, the prosecutor argued that the CSLI showed that Carpenter was right where the robbery was at the exact time of the robbery. Mr. Carpenter was convicted of those robberies, and he was sentenced to over 100 years in prison. Mr. Carpenter's case went to the Supreme Court, where he argued that the government should have gotten a warrant to get all that information about his cell phone location for all of that time. Yes, said the Supreme Court, it should have. CSLI provides a detailed chronicle of a person's physical presence, compiled every day, every moment over several years. Such a chronicle implicates privacy concerns that are protected by the Fourth Amendment. If law enforcement wants that information, it needs to ask a court for a warrant. But wait, said the prosecutor. Okay, not the actual prosecutor, but the government lawyers on behalf of the prosecutor. This court has held over and over that when the government gets records from a third party, like a bank or a phone company, it is not a search for the purposes of the Fourth Amendment. People do not have a reasonable expectation of privacy in records held by other people. We didn't get any information from Mr. Carpenter. We got it from Metro PCS and Sprint. That means we didn't search Mr. Carpenter at all. Actually, said the Supreme Court, you did search Mr. Carpenter. Cell phone records are special. When the government tracks the location of a cell phone, it achieves near-perfect surveillance, as if it had attached an ankle monitor to the phone's user. Moreover, those CSLI records reveal private information. A cell phone faithfully follows its owner into private residences, doctor's offices, political headquarters, and other potentially revealing locales. Mr. Carpenter had the right to expect privacy against that kind of tireless and absolute surveillance. Therefore, you did conduct a search. Therefore, you did need a warrant. Whoa, said the prosecutor. That's a big change in the law. So you're saying that the Fourth Amendment might protect that digital data created and held by third parties like cell phone companies or internet providers or Google? Basically, yeah, said the Supreme Court. Carpenter is a major case in a line of very important, relatively new cases. Cell phones, GPS tracking, digital records, and data trails were all unheard of when the Supreme Court developed most of the rules regarding the Fourth Amendment. Carpenter and these other new cases grapple with the revolutionary impact of these new technologies on our privacy and on the government's ability to get information about us. Through these cases, the Supreme Court is figuring out how to bring constitutional protections for individual privacy into the modern digital age. Okay, let's read the case. Carpenter versus United States, decided in 2018, expanded the kinds of information gathering and surveillance that are potentially protected by the Fourth Amendment and by the warrant requirement. Carpenter is the third major case in a line of cases dealing with electronic data and surveillance. In United States versus Jones, the Supreme Court decided, for example, that the police need a warrant to place a tracking device on a person's car. In Riley versus California, the court decided that police need a warrant before they can search the cell phone of a person who has been arrested. Carpenter extends this concern for digital privacy into the arena of third-party information, that is, digital records created or obtained by third-party institutions like cell phone companies, internet service providers, and social media platforms. Although Carpenter's holding is technically limited to the specifics of cell site location information, CSLI, its implications for all these many new digital arenas is enormous. Carpenter is a long and rich case, so we will just touch on its main features. Prosecutors believed that Timothy Carpenter was connected to 6 robberies. They got his cell phone number from another suspect. And then they got a court order under the Stored Communications Act to get Carpenter's cell phone records. The important thing to note here is that the requirements to get that court order were much lower than the requirements needed for a warrant. The government only needed to show reasonable grounds to believe that the records sought are relevant, which is far less than probable cause. The government got approximately 4 months' worth of CSLI records for Carpenter's phone, and it used those records extensively at trial to show that he was in the vicinity of the robberies. Carpenter was convicted of 5 robberies and 5 related counts of carrying a gun during those robberies. The mandatory minimum sentences associated with those gun counts largely accounted for his extraordinary sentence of over 100 years in prison. The Supreme Court decided that Timothy Carpenter was subjected to a search and therefore entitled to Fourth Amendment protection when the government got those CSLI records from his cell phone carriers. Because it was a search, the government needed a warrant, which it didn't have. This finding that getting those CSLI records constituted a search required the court to revisit 2 lines of established doctrine because, as the court put it, this sort of digital data does not fit neatly under existing precedents. The first line of doctrine is about being tracked in public. It is embodied in the case United States versus Knotts, which held that the government could freely monitor a beeper in a person's car because a person traveling in an automobile on public thoroughfares has no reasonable expectation of privacy in his movement from one place to another. Since our public location is voluntarily conveyed to anyone who wants to look, it is therefore not private for Fourth Amendment purposes. The court somewhat modified this approach in United States versus Jones, one of the new digital privacy cases. In that case, the government placed a tracking device directly on a suspect's car. And the court held that that intrusion itself, the physical trespass of the car, constituted a search. In addition, 5 justices also wrote separately to emphasize that the long-term pervasive surveillance by GPS tracker was itself a search, a kind of alternative grounds for the decision. This is one of the hallmarks of the new privacy cases. The justices may agree that some sort of search or privacy violation has occurred, but they often disagree on the legal grounds for reaching that conclusion. The second line of cases is the so-called third-party doctrine. The court held that we lose our expectations of privacy in information that we convey to third parties, or that third parties maintain about our relationship with them. For example, in United States versus Miller, the court held that the defendant did not have an expectation of privacy in his bank records, which were held by the bank. Likewise, in Smith versus Maryland, the court held that the defendant lacked a reasonable expectation of privacy in the pen register maintained by the phone company that kept track of all the phone numbers that he had called. If you recall the Hoffa case, you will recognize the reasoning that individuals take the risk in revealing their affairs to another, that the information will be conveyed by that person to the government. In both Smith and Miller, as in Hoffa, because the defendants had no privacy interest, the court held that the government had not conducted a search at all when it obtained those records. The Carpenter court decided that CSLI is governed by neither line of cases. As it wrote, "We hold that an individual maintains a legitimate expectation of privacy in the record of his physical movements as captured through CSLI. Notice how this holding distinguishes CSLI from the beeper tracking that took place in Knott's, even though both reflected the defendant's public movements. Even more importantly, the holding distinguishes CSLI from bank records, phone records, and other information given to or held by third parties. As the court put it, we decline to extend Smith and Miller to cover these novel circumstances because of the unique nature of cell phone location records, the all-encompassing record of the holder's whereabouts that it provides, and because of how those records can reveal the privacies of life." The court noted several times how universal the threat of exposure can be. This newfound tracking capacity runs against everyone. The court concludes by ostensibly limiting its holding. Calling the decision a narrow one, the court writes that it is not deciding whether other kinds of digital information might also be protected. And it also clarifies that it is not disturbing Smith and Miller, that is, previous law regarding bank records, phone records, and other kinds of more analog third-party data. But notwithstanding these caveats, the implications of the Carpenter decision to roll back third-party doctrine are potentially far-reaching. 4 justices disagreed and wrote lengthy dissents. I have only given you excerpts from 2 of them. First, Justice Alito expresses particular concern about how this new decision might interfere with subpoenas, that is, common court orders that require people to turn over documents. He argues that a court order to produce documents, like the order obtained in this case, is much less intrusive than an actual search conducted by government officials, and thus should not be constrained by the Fourth Amendment in the same way. Justice Gorsuch also dissented, offering a substantially different perspective on Fourth Amendment doctrine. He proposed that instead of asking about reasonable expectations of privacy, Fourth Amendment protection should turn on property law, that is, whether the information at issue actually belongs to the suspect in some way. This was the trespass argument that prevailed in Jones, the GPS tracking case. Justice Gorsuch points to the language of the Fourth Amendment itself, which protects the right of the people to be secure in their persons, houses, papers, and effects. The most important word in that sentence, obviously, being the word their. Justice Gorsuch ends his dissent by inviting future advocates to argue along these lines, noting that these arguments have gone unmade. Carpenter is just the beginning of these constitutional changes. Digital information opens up brand new legal territory on which the justices of the Supreme Court are not in agreement. Carpenter thus advances what promises to be a long, continuing argument at the Supreme Court about the very nature of privacy in the digital age.
There has been an enormous amount of literature and commentary on the significance of this line of cases, these privacy in the digital age cases, Jones and Riley and now Carpenter, with respect to what they mean for privacy. But I want to take this last minute to think about what they mean for criminal procedure itself, and particularly going forward with the new composition of the court. So the traditional standard story that we tell about criminal procedure Modern criminal procedure was basically invented by the Warren Court in the 1960s with the landmark cases that we're all familiar with, Gideon and Miranda and the exclusionary rule in MAP, and that the court created those neutral general principles with a deep awareness of and an eye on the vulnerable. That the court understood that our criminal justice system is particularly harsh on the poor, that it is especially brutal and unfair to African Americans. And so in the 1960s, it created basically a criminal procedure safety net. A net of rules that apply to everyone, but that has special protective salience for the most disadvantaged, who are, of course, the average resident of our criminal justice process. And we've basically been grappling with the retraction of that model for the last 4 years. These cases are different. The court has made very clear, especially in Carpenter, that it is not concerned so much with the privacy incursions into the lives of the most vulnerable, but as Chief Justice Roberts says several times in Carpenter, these incursions affect everyone. Everyone, he keeps telling us, namely us. The privileged, the well-educated, the well-resourced, who are not accustomed, as are the average resident of the criminal justice process, we are not accustomed to the notion that the police may be lurking behind our daily activities and our daily lives in the ways that these new technologies make possible. And so I want to suggest that we are leaving the era of the criminal procedure safety net, and that we may be entering an era of trickle-down criminal procedure. I'll just stop with that.